You found the podcast, Go Beyond the Brief, where we take a deep dive into the societal currents shaping our lives. Together, we'll explore the often unseen forces at play. We'll examine the research, dissect the data, and most importantly, if you're seeking to understand what's shaping our society,
let's unpack this.
this
Today,
is the place.
we're doing a deep dive into a really specific source.
Right. A verified complaint and summons.
Filed in New York Supreme Court, November 2023. And this isn't just, rehashing a lawsuit.
No, not at all. We're focusing on the actual allegations in the document and, importantly, the legal mechanics behind it.
Exactly. How it targets not just a celebrity, Russell Brand, but also several major corporations.
Which is a key part of the strategy here.
So the plaintiff is Jane Doe, resident of New York, defendants, Russell Brand, obviously, and then these 5 corporate entities.
Yeah, let's list them because it matters. Warner Bros. Pictures, Inc., Warner Bros. Discovery, Inc., MBST Entertainment, Inc., Bender Spink, Inc., and Langley Park Pictures.
That's a mix of production, management, the big studio. It covers the bases.
Absolutely. But before we even get to what allegedly happened, we need to talk about why this lawsuit can even happen now. Because the events were, over a decade ago?
Right. That's the crucial piece, isn't it? The legal gateway.
It really is. It's brought under the New York Adult Survivors Act.
Yeah.
CPLR 214J.
Okay, so what does that mean for someone listening?
Well, basically, claims like this usually have a time limit, a statute of limitations. That limit would have expired ages ago for something in 2010.
Makes sense.
But the ASA created this temporary look-back window. It allowed people to file claims for sexual abuse that were previously blocked by those time limits.
So it reopened the door, legally speaking.
Exactly. It turned something that was, legally impossible into a live case.
Yeah.
And that changes everything for these companies, looking back at past events.
Huge implications for potential liability from way back when.
Precisely. It lets the plaintiff connect the alleged 2010 incident to this filing in 2023.
Okay, so using that act as the bridge, let's talk about the setting described in the complaint. Where and when?
Right. The complaint is very specific. It's the set of the movie Arthur, the remake.
Okay, I remember that film.
Filming in New York County. The date given is on or about July 7th, 2010.
And the location.
Specifically, during filming at Le Cirque restaurant. The famous spot.
Right. And the plaintiff, Jane Doe, she was working on the film.
Yes, employed as an actor. The complaint clarifies she was an extra on set that day.
And the complaint, it seems to set a scene pretty quickly, doesn't it? About Brand's condition.
It does. It alleges that on that specific day, July 7th, Brand was visibly intoxicated.
Visibly intoxicated on set.
Yes, and carrying an open bottle of alcohol right there at Le Cirque while filming was happening or about to happen.
Wow. And why is that detail included so prominently?
Because the plaintiff uses it as, the first example of negligence by the companies. The argument is, here's the star, visibly drunk with alcohol on their set, and nobody stepped in. No one from the corporate defendants or their teams did anything to, manage the situation or protect the environment.
So that's the first alleged failure to supervise moment. They saw it or should have seen it and did nothing.
That's the core of the argument for that specific detail. It sets up this idea that the environment was permissive, maybe even uncontrolled.
Which then leads into the first specific alleged incident. Let's walk through that timeline as laid out in the complaint. It starts publicly.
Yes. The first alleged encounter is described as happening openly. Plaintiff was sitting at a table, waiting. Brand allegedly makes eye contact.
Okay.
Then, the complaint alleges, he pulled his erect penis out of his pants in an open and obvious manner, facing her directly.
Openly, in front of others.
That's the allegation. In the presence of everyone on set, which would include employees of these corporate defendants.
And the complaint stresses the reaction, or the lack of one.
Exactly. That's critical for the corporate liability part. It alleges no one disciplined him, no one reprimanded him, no one stepped in to protect the plaintiff or, frankly, anyone else.
So the inaction itself is a key allegation.
Yes. The complaint says the behavior was treated as acceptable. And if that was acceptable, the argument goes, it essentially greenlit further worse behavior. It fostered an environment where misconduct could escalate.
Which, according to the complaint, it did. Later that day, there's a second alleged incident.
That's right. The setting changes. It's during a break. Plaintiff goes into a multi-stall restroom.
Okay.
When she comes out of her stall, the complaint alleges Brand was inside the restroom, waiting.
Inside the women's restroom, or just a general restroom.
The complaint specifies a multi-stall restroom implying a public or shared one on set. And it alleges he was physically blocking the exit with his body.
Blocking the exit. And again.
Again, pants pulled down, erect penis exposed, according to the filing.
And this is where the alleged assault happens.
Yes, in that confined space. The complaint states she was very scared. He allegedly pressed himself against her back, forced her into a stall,
Okay.
repeatedly asked her to kiss his penis, and then allegedly forced her head down, initiating oral sex.
And how did it end?
She managed to push him away and escape the stall, escape the restroom. That's how the complaint describes it.
So those alleged actions form the basis for the direct claims against Brand himself, right? Sexual assault, battery.
Correct. Sexual assault, sexual battery, false imprisonment, because she was allegedly blocked in, and intentional infliction of emotional distress. Those are the specific torts, the civil wrongs alleged against him personally.
But there's a detail about her escape that seems aimed squarely at the corporations.
There is, and it's a really stark allegation.
What is it?
The complaint alleges that when she finally got out of the bathroom, there was a production crew member standing directly outside the door.
Just standing there.
Not just standing there. The allegation is specific. Positioned as if they were guarding the door to ensure that Brand would not be interrupted.
Guarding the door. That's a huge leap from just failing to supervise.
It's an enormous leap. It shifts the claim from negligence, failing to act, to potential complicity or active facilitation. Taking an action, having an employee posted there, that allegedly enabled the assault.
If true, that directly involves an employee of one or more of the corporate defendants.
Precisely. It alleges active participation by the production apparatus itself and the immediate aftermath for the plaintiff.
What does the complaint say happened to her job on the film?
It says she wasn't asked back for the next 2 days of filming she was scheduled for. She was only paid for that one day, July 7th.
Okay. So let's pivot now to how the lawsuit tries to legally tie all this back to those 5 companies. Warner Bros., MBST, the others. This is the core legal strategy, right? Proving corporate culpability.
Absolutely. This is where the heavy lifting in the legal argument happens. It revolves around a concept called negligent hiring, retention, and supervision.
Okay, break that down for us. Negligent hiring, retention, supervision.
Sure. It basically means the plaintiff is arguing the companies failed in their duty to keep the workplace safe in 3 ways. 1, hiring. They hired Brand when they allegedly knew, or should have known, he had tendencies towards this kind of behavior.
2, retention.
Retention. They kept him employed, kept him as the star, even after they had reason to know he was a risk, maybe based on prior incidents or warnings.
And 3, supervision.
Supervision. While he was actually on their set, using their facilities, working for them, they failed to adequately watch him, control him, or intervene when he acted inappropriately, like the alleged intoxication or the first exposure incident.
Okay, but the companies might argue, how could we know about his private behavior or past issues? How does the complaint address that knew and/or should have known standard?
That's a critical point. The complaint argues this wasn't some hidden secret. It points directly to Brand's publicly reported history.
Ah, so they cite media reports.
Yes. Explicitly. It mentions specific things. Allegations made publicly by 4 other women, spanning from 2006 to 2013. It references alleged incidents of him flashing people on the sets of the BBC and Channel 4.
So public knowledge stuff.
Right. And maybe most damagingly, it mentions allegations that some of Brand's own colleagues felt like their job involved helping him meet young women, making them feel like, and this is the word used, pimps.
Citing those public reports seems tactically important. It suggests the companies didn't need some secret internal memo to be aware.
Exactly. It argues that basic due diligence, just paying attention to widely available information about the star they were hiring for a major film, should have put them on notice.
Yeah.
It lowers the bar for proving they should have known.
And based on that alleged knowledge or willful ignorance, the complaint goes further than just negligence, right?
It does. It alleges the corporations condoned and encouraged the misconduct. Not just by failing to act, but, and this is another strong claim, by providing Brand with staff and facilities to aid in his sexual abuse of women on set.
Staff and facilities. That sounds like the guarding the door allegation again, but broader.
It could encompass that, but also potentially things like assistants, dressing rooms, drivers, the general infrastructure of a film production. The argument is that the production structure itself was weaponized, or at least made available, to facilitate this alleged behavior.
Wow, so it reframes the whole set environment.
And it tends to, yes, from a workplace to potentially an environment where abuse was enabled. This culminates in a really powerful claim about the corporate culture.
What's that specific claim?
Paragraph 138, it alleges the corporate defendants created and fostered an environment where sexual assault was permitted, accepted, institutionalized, and encouraged.
That word institutionalized, that feels significant legally.
It's incredibly significant. It suggests this wasn't just a one-off failure or a single rogue actor. Institutionalized implies the problem was embedded in the system, in the way things operated, perhaps through repeated inaction or turning a blind eye.
It suggests the system itself was flawed, not just the supervision on one particular day.
Precisely. And that kind of allegation is designed to justify seeking major changes and damages against the institutions themselves.
Now, to hold all 5 companies responsible, the studio, the production companies, the management company, they need to link them legally, don't they?
Yes, they do. That's where the concept of agency status comes in. The complaint has to establish these connections.
How does it do that?
It alleges 2 key things. First, that Brand himself was acting as an agent, servant, or employee of all 5 corporate defendants at the relevant times.
Okay, connecting him to everyone.
And second, crucially, it alleges that the corporate defendants were agents of each other.
Why is that second part, them being agents of each other, so important?
Well, think about it strategically. It's often called the deep pockets argument. If, say, the smaller production company, Langley Park, is found liable, but it's also proven they were acting as an agent for the massive parent company, Warner Bros. Discovery.
Then Warner Bros. Discovery could be on the hook for Langley Park's actions or failures.
Exactly. It potentially makes the entire corporate structure liable for the actions or omissions occurring under any part of its umbrella. It ensures that if liability is found, the plaintiff can seek damages from the entities with the most substantial financial resources.
Makes sense. So, bringing it all together, what is the plaintiff actually asking for in this lawsuit? What are the damages they're seeking?
They're seeking quite a lot across several categories. First, there are compensatory damages.
Okay, what does that cover?
That's meant to compensate Jane Doe for the actual harm she allegedly suffered.
Yeah.
Things like severe psychological injuries, emotional distress, mental anguish, embarrassment, humiliation.
The personal toll.
Right. And also economic losses past and future medical bills, maybe lost earnings, that kind of thing. The goal is to try and make the victim whole, again, at least financially.
But the complaint doesn't stop there. It also asks for punitive damages.
Yes, against both Brand and the corporate defendants.
Now, punitive damages are different, right? They're about punishment.
Exactly. They aren't just about compensation. They're intended to punish the defendants for particularly bad conduct and deter others from doing the same thing in the future.
Is it common to get punitive damages, especially against big corporations? What's the standard?
It's a high bar. You generally have to prove the conduct wasn't just negligent, but wanton, reckless, and/or malicious.
And how does the complaint argue the corporations meet that standard? Malice seems like a strong word for a company.
Well, the argument ties back to everything we discussed. Alleging they knew about Brand's history, they provided the facilities, they allegedly had an employee guarding the door, they failed to act despite visible intoxication. The plaintiff is arguing that all this adds up to a conscious disregard for her safety, which could be seen as reckless or malicious behavior at the corporate level.
So if they prove that level of disregard, punitive damages could be substantial.
Potentially, yes. They serve as a punishment and a warning to the industry.
Are there other things requested besides money?
Yes. The plaintiff also seeks a declaratory judgment. Basically, a formal declaration from the court stating that the defendant's actions violated New York law. It's a legal finding of wrongdoing.
And also an injunction.
Right. A permanent injunction. This is forward-looking.
How so?
It would be a court order restraining the defendant's Brand and the companies from engaging in this type of unlawful conduct again. It forces changes in behavior or policy. While damages look backward, an injunction tries to prevent future harm.
Okay, so summing all this up, the real significance here, enabled by that Adult Survivors Act, seems to be less about just this one alleged incident and more about challenging the system.
I think that's a fair way to put it. It's using this specific horrific alleged event as a case study to argue for broader institutional accountability in the entertainment industry.
Accountability for how power operates on set.
Exactly. The complaint essentially argues that the power, the fame, the star status given to someone like Russell Brand wasn't just ignored by the corporations, but was actively enabled, maybe even protected, by a system that prioritized the star over the safety of other employees.
And the ASA provided the tool to bring that argument forward years later.
It provided the legal key to unlock that door. It allows the plaintiff to say, these powerful organizations allegedly created or tolerated the conditions for this abuse, and they need to be held responsible, even now.
It really shifts the focus, doesn't it? From just the alleged perpetrator to the environment that might have allowed it.
Absolutely. And that leaves you, the listener, with a pretty complex thought, I think.
Which is?
Just how difficult is it to prove corporate liability for this kind of institutionalized failure, as the complaint calls it, especially in an industry like entertainment, built so heavily on powerful figures and sometimes blurring lines? When does inaction become condoning? When does failing to supervise become actively enabling?
And can a lawsuit like this actually force a meaningful change in that kind of embedded culture?
That's the multi-million-dollar question, isn't it? And it's what this legal filing forces us all to consider.